I've turned away from making of offers to withdrawal and variation, and I justify putting the sunset clause debate in that earlier section because that's something you do at the time you make the offer. And if you think about it, we've, in times of economic hardship, we've put in a rule there that means you can save a stamp in the way that you do these things. But I'm now turning to the question of withdrawal or variation after you've made the offer. And we start with a statement of the bleeding obvious, if you'll allow me to say so. 36.91, so on page 6, a Part 36 offer can only be withdrawn or its terms changed if the offeree has not previously served notice of acceptance. Pretty obvious, but it wasn't actually spelt out before. Everything else I say about variation would assume that there's been no notice of acceptance before you decide to vary or withdraw. On that assumption, there are two regimes, really. There's the laissez-faire one. Once the relevant period has gone by, I keep saying 21 days. I don't know how many of you really make offers choosing a different number of days, but it's got to be a minimum of 21 days. There's the laissez-faire option, which is after the relevant period, you can pretty much do as you like. And then there's the regulated position of what happens during the 21 days. Well, that dichotomy is still there in the new rules, and I'm going to deal with the 3610, which is the discrete rule now that deals with what happens during the relevant period separately. Just before I do, though, there is something new in 36.9. If you look at paragraph 5, we've put in a provision there for what happens if you make a more advantageous offer. We're talking here about variation of the original offer to make it more advantageous. Now, of course, you needn't actually do it that way. Because Gibbons says you can stack your offers, you could simply make a fresh offer. But if instead you write a letter of variation and vary the offer, then it has two consequences. First, it's treated as a new offer. And secondly, there is a new relevant period, a new 21 days for the offeree to consider whether to take it. Let's put a little bit of flesh on that. If, let's take an example, a defendant's offer to settle a money claim, originally £500,000 by way of Part 36. A year later, you're doubling that to £1 million. It needs to be treated as a new offer and will be under this new rule because, of course, if at trial the claimant only gets £100,000, you'll want to be able to rely upon the earlier in time offer and get your costs from that far earlier date. So that needs to be in there, and it is in there. The new relevant period is required, of course, because the money's gone up. The offeree needs to think about it. But contrast that with the position in respect of a less advantageous offer. We don't have a similar provision for less advantageous offers because that, it seems to us, is a true variation. If your offer's going down from the million to the £500,000, you're never going to have the £1 million. That has gone. It's a true variation of the terms of the offer. And secondly, you don't deserve another 21 days to think about it. You've turned down $1 million for the last year. Tough. It's now £500,000. And if you want to accept the £500,000, fine, but you're accepting it late. You're accepting it out of time. So it's not treated as the making of a new offer. I turn then to, as I say, the more regulated position during the 21 days. There was very little guidance in the old rules. What they effectively said is that you can do it, but only if the court gives permission. There's, I'm afraid, this terrible case that was mentioned briefly by Neil in his introductions of Evans and the Royal Wolverhampton Hospital of 2014, a case in which a designated civil judge heard on an ex parte basis an application by a defendant to withdraw its offer during the 21 days. Not only did he grant it ex parte, but he ordered that there would be no need to have a note of the ex parte hearing, and secondly, that the claimant couldn't see the evidence upon which he had made his order. Luckily, Mr. Justice Leggett came to the rescue. The designated civil judge on the inter-parties hearing decided he'd better refer it to a full High Court judge, probably a right decision, and as a result, I don't think it will need to trouble the Court of Appeal. But it was a plain breach of natural justice, and if you're interested in the case, there's an excellent article by Ruth Pratt of LexisNexis in your mini magazine provided by LexisNexis. But let's assume that you at least remember as a judge, if any of you sit, that you better hear both sides on this. Let me work through how it works under our new rules. There is more guidance. The first thing to say is that whether you want to make an offer, accept an offer, vary an offer, withdraw an offer, it's all done by serving written notice that that's what you're doing. That hasn't changed. So if you want to withdraw or vary during the 21 days, you serve notice that that's what you want to do. But you no longer have to rush off to court. And our logic's really this, that you might as well wait till the end of the 21 days, because if the offeree doesn't actually want to accept your offer anyway, why are we forcing you to make an application to withdraw it? Remember, you can withdraw it without any problem on day 22. So what's the point in making you file an application notice and go off to a judge if they don't want it anyway? So the way in which it will work now is you serve your notice. If the other side decide they would like to accept it, then we need to go a step further. But if they don't, it's automatically withdrawn or varied. If they decide they do want to accept, then as the offeror, you then have a period of time within which to decide whether to take this before a judge. You've got 7 days, and if you don't make your application within 7 days of the indication the offeree would like to accept, then it's accepted. The case is settled. But if you make your application, then there's no argument anymore, which there was under the old rules, that you might need to file your notice of application before acceptance. It was wrong as an argument, but it was seriously argued in some of the cases. And if you get it then in front of a judge, para 3 of this rule tells you what the test is. It's not a change of law, it's an example of codification. The rules previously didn't tell you the answer to this. The Evans case told you the answer, and a case called Flynn and Scougal, Court of Appeal in 2004, told you this answer. But what it is a change of circumstances you would need to show to justify your withdrawal or variation, and also to show that it's in the interest of justice that you be allowed to do it.